Next slide.
I'm sorry, let's go to the next slide.
Yeah.
Okay, so in terms of what is going to happen with the resolution of the case in terms of the settlement, there are a couple of things that will happen. After all the registration forms are in, claimant forms are in, all the evaluations of tests, the claim forms, etc., the individuals, you in the community who are seeking to be part of the resolution and settlement of the claims will be awarded a certain amount of money that is based upon what's referred to as an evaluation or a monetary grid based upon ages, the amount of lead in someone's systems, if they can prove that. There's property claims, valuation of the property claims, there's adults, and there's business owners. So the four basic or prime categories are minors, adults, business, and property related claims. And out of this fund that is being set up as well is an attorney's fees. Now, many of us have been asked, I know Mike and others on this call have been asked by you in the community, well, how much money is the lawyers getting? Well, we really don't know how much money the lawyers, us, are getting for the many, many years have been involved and the millions of dollars we have spent on cost of the litigation, because ultimately that's going to be left up to Judge Levy. There'll be a petition, what we call papers or pleadings that we file with the court and Judge Levy seeking attorney's fees in the case, but ultimately Judge Levy will have a hearing on that issue where again, everybody will be able to weigh in on that and and say whatever they would like to say on those issues. But ultimately Judge Levy will be the judge, if you will, that will make that decision. Then there will be another category of that's part of the settlement is for whatever reason, there'll be some individuals that for, again, whatever reason will refer to as opt out of the settlement. In other words, they don't want to participate. And you or others may be free to do that. You can do it by just not participating, not sending a registration form, but some type of form that you want to actually opt out and not be part of it. And again, you can do that, but if you want to participate in the litigation, you'll have to end up doing that on your own and seeking other counsel to do that, finding an attorney to do that, finding an attorney that will front the cost of the litigation that can take, you know, probably many, many, many more years down the road, including appeals and litigating through trial. But that is your right to do that. But we would hopefully provide you information where you'll really consider not doing that because it can be quite an uphill battle from here on out. And then there are going to be minors that either want to not participate now or may not know about the settlement for whatever reason. And when they turn 18 years of age, they can then seek reimbursement or a claim at that time, and there will be some funds that will be held between now and when those minors turn 18. So even though you say are 13 years old now and you don't do anything when you become 18 and you remember that there was this claim out there and the Flint water crisis, there will be some money there that minor can then make a claim. Mike, Leslie,
Yeah, let me
add anything?
let me just emphasize one point that Ted has made, and that is on the opt-out decision. That's a very important decision. If you decide that you need to litigate this case yourself, and again, if you opt out, you have the right to sue the state of Michigan, McLaren, if it's a Legionella case, and the city of Flint, because opting out means that you're not participating in the settlement with the state of Michigan, the city of Flint, or McLaren. However, as Ted has pointed out, it's a very difficult road ahead for those who opt out. And for some, that is perhaps the best solution. But before you decide to opt out, you really should talk to a knowledgeable attorney about the pros and cons of staying in the settlement program or opting out. And even though we as class counsel will not be able to represent you in your individual claims if you opt out, we are certainly available and will be willing and happy to give you any counsel and advice that you may feel is appropriate. We'll give you our best opinion and estimates and things of that nature to help you make that important decision. It's really important that you get good legal advice before you decide to either opt out or to participate in the settlement program. It's a very important decision, and you need to get professional advice.
Okay, let's go to the next slide. Again, there's a lot of detail to the settlement. The master settlement agreement is, I don't know, 50 to 100 pages of very detailed legalese, phrases and words. But we have it on the website at flintwaterjustice.com. Anybody is free to go there. If you do go there and you do read it and you have questions, please write the questions down. Feel free to give us a call. We could walk you through it, answer any questions that you have. The interim class counsel team has worked to make sure that there's complete equity in the settlement terms and the process and the recoveries, that there's parity, so that people with the same or similar ages, same or similar type of injuries, get the same or similar types of recovery of a dollar amount. Go to the next slide. Okay, so we want to make sure that you remember about the December 21st hearing in front of Judge Levy, so everybody can watch that proceeding of the preliminary approval hearing. Then we'll watch out for a court order from Judge Levy on the preliminary approval. And then we have a January 28th, 6 p.m. For our next town hall meeting. I think there may be a few questions that are out there. So David, if you want to ask those questions, we can try and answer them as best we can.
Hey, David, before we go on, Ted and Michael, there are a couple of potential guardian ad litems on this call that I invited to listen in. Can we go back and explain a little bit more about the children and how we may have to set up estates for them and how their money could be set aside and handled?
Yeah. Go ahead, Cynthia.
Oh, okay. Okay. So for you guys who are courteous enough to join us today, I see 3 of the guardian ad litems I've been in contact with for the last couple of days. I did receive a list, Ted, and Michael, you already know that I received a list of about 34 different potential guardian ad litems who would be willing to assist us. We know that there are a lot of children involved in this litigation, and the estates are going to have to be opened up. So to those who are on this call, thank you very much for joining in. And all of you who have minor children, you'll know more about this a little later, but there is a process where your children would have to have an estate opened up in probate court, Genesee County, because you will not have direct access to their money. You will have to be appointed as a conservator to be over their money, and you will need the assistance of somebody that knows how to take you through that process, and that is a guardian ad litem. Guardian ad litem is an attorney that's appointed by the probate court to assist you to make sure that everything is handled correctly and fairly and that your children's monies are safeguarded. So you'll hear more about that as the process goes on, but be prepared that it's another step to this process that would have to take place before any final amount of money is distributed on behalf of minors.
Yeah.
Thank you.